Good evening. This is John Milburn for Laws 12067 Environmental Law. We're in week 6 of 2017. Today or tonight, we're dealing with chapters 9 and 10 of the textbook, which deal with the issues of strategic environmental planning and assessment. So last week, we dealt with statutory instruments and regulatory tools in the context of ecologically sustainable development. This week, we concentrate on planning law with an emphasis on strategic environmental planning and development control. The practice of environmental law is heavily involved in the planning process. In other words, the Planning Act 2016 provides detail about the management of the process by which development occurs. It also specifies how state, regional, and local planning documentation is implemented in practice. This year, we're offering environmental law within the context of the new regime, that is the Planning Act 2016. The previous law was governed by the Sustainable Planning Act of 2009, and prior to that, the Integrated Planning Act. So there has been a succession of pieces of legislation at a state level in Queensland that deals with these issues of planning law and the process. It's relevant to you to consider that the development that you might be dealing with at a particular time may relate to any one of those three pieces of legislation or legislation prior to the IPA. But we're teaching law as it is at the moment. So that's the planning law. Just a brief note about the previous law. Development applications were assessed in accordance with the Integrated Development Assessment System, IDAS. And for a definition of IDAS, as it was, see section 230 of the Sustainable Planning Act of 2009, which said that IDAS is a system detailed for integrating state and local government assessment and approval processes for development. So we don't have IDAS under the Planning Act, but we have something similar. There are forms, as you might expect, and in the Planning Act 2016, there are new approved forms that must be used for applications lodged under the Planning Act of 2016. If you have an application that predates the introduction of the Planning Act, in other words, prior to the 3rd of July 2017, refer to the old Act and the old forms. The website material produced by the Queensland Government, in my view, is excellent in this area. So I would recommend that if you're viewing this session as a recorded session, that you now pause and have a look at the resources section available to you through the Department of Integrated Planning. I'll come back to that in more detail. So there are new resources, there are new forms that you must consider in the context of making applications for development. But before we talk about that specific level of detail, let's just overview this in terms of the legal system and planning and environment law. So the legal system, of course, at a basic level, means that there are differences between Parliament, the executive and the judiciary. Now, we all know that. We know that Parliament makes legislation, the executive implements the legislation in a workable manner, and the judiciary, which is the most distinct of the three branches of government, considers the legislation and, to a degree, the previous case law in coming to a decision to resolve a dispute. So breaking that down a little more, Parliament creates state, regional and local planning documents. The executive considers development applications, and throughout this unit I place a considerable emphasis on litigation, which of course occurs at the third level of government, judiciary. So what can people do if they're unhappy with environmental law decisions? Well, it depends at the level at which the decision is made first up, because members of the public may have very little rights to do anything at all in certain ways. So, for example, if a member of the public is unhappy with respect to planning and environment decisions, they could be at one of the three levels, or they could voice their concerns at one of the three levels. So, for example, A member of the public or a group may be unhappy with legislation that has a general effect, such as the Planning Act, or specific effect, such as the Century Code Development Act. That is, they're unhappy about something which was decided at a parliamentary level. The remedy is to lobby to seek change at the time of election, and it's not possible for individuals to challenge what Parliament introduces by way of legislation. They may be happy with the way in which the planning schemes are developed and brought into effect, that is, at the executive level. And it's not possible for an individual to challenge planning schemes introduced by way of executive function. Individuals may lobby against the introduction of planning schemes, but they have no right to appeal a council's executive approval of a planning scheme. Again, the ramification for the executive is at the time of the election. Finally, they may be unhappy with the executive decision made by an assessment manager, made in relation to a particular development. If it's an impact assessable development, then that is a matter that can be determined at the third level by the judiciary, and potentially people can be involved at that level, members of the public. So you'll see that there are different ways in which the public can become involved, but to varying degrees of effect. All right, so development applications may well become the subject of litigation. And that'll occur when the assessment manager makes a decision. And we've only got 2 online, so I won't be mean and ask too many questions, but can either of you tell me what is meant by an assessment manager?
I believe, John, someone from the council level, I would imagine, that is looking after the assessment and planning and development applications in that area.
That's it, yes. Usually it's a council. Not always, but usually it is a council. So thank you, Kim, for that. And sometimes you'll hear of development applications being considered by the assessment manager and concurrent agencies. Concurrent agencies effectively have a right of veto, and they come in as third-party organisations to consider developments, not as the assessment manager, but as a concurrence agency. Okay, so a development application is considered by an assessment manager. Let's say it is a council, which is usually the case. What can the council assessment manager do in terms of an application? Well, there are pretty much only 3 things that the council officer can do. The council could approve the development, which is then subject to opposition, or it could approve a certain development which contains conditions, and members of the public may challenge those conditions, or indeed the developer, the applicant, may challenge those conditions. Or thirdly, the council may refuse the development, and the developer can then appeal to the court. So in real terms, if the council approves or approves with conditions, then an objector or an applicant can take the matter to court, or if the council refuses the application, the developer can go to the court, but only in limited areas. If someone is a concerned citizen and they believe that it's appropriate and necessary to challenge a development approval, they need to consider basic arguments. And one general argument that you can use and keep up your sleeve, as it were, is that the matter of the approval conflicts with the planning scheme. So we come back to what is in the planning scheme. If the development is not consistent with or conflicts with that planning scheme, that would be a strong ground for appeal against the decision of the council. Any questions so far? Or we're right to go? All right, just unmute the microphone or ask through the chat facility. Right, so the important court where matters are considered in relation to environmental development applications is, of course, the Planning and Environment Court. We know that the P&E Court is essentially part of the District Court in Queensland, and many District Court judges have a concurrent ability to hear matters either in the district court, in its usual jurisdiction, which might include criminal law, for example, or the Planning and Environment Court, and it's the same judge who will preside in either court in various instances. Not every district court judge has a commission to hear matters in the P&E court, but all judges of the P&E court are drawn from the pool of district court judges. So the Planning and Environment Court considers certain decisions made by an assessment manager, but not every decision. In other words, there has to be a threshold of importance before the P&E court will consider it. And you would need to look at an application which is an impact assessable development. So what that tells you is that there are certain categories of development application that require a certain level of commitment by the development manager or the assessment manager in making a determination. Some development applications are assessable by the assessment manager, but many are not. Many are not assessable at all. But if it's an impact assessable development, then we look to the P&E court. Now, the Planning and Environment Court was set up under the Planning and Environment Court Act of 2016. That's a little bit confusing in that the P&E court well and truly existed before the P&E Court Act of 2016. But what happened with the introduction of the Planning Act 2016 is that the content of it was greatly reduced from its predecessor, the Sustainable Planning Act. And to be honest, many of the things that were contained in the previous Sustainable Planning Act 2009 were moved not only into the Planning Act 2016, but related legislation or regulation. So you'll see things that were previously in the Sustainable Planning Act that now appear in the Planning and Environment Court Act or the Planning Regulation 2017. So in some ways, whilst it appears to be greatly simplified, it isn't really, because much of the content has simply been moved into different areas. What we have seen with the introduction of the Planning Act is the introduction of the Development Tribunal. Now, this is a new area for dispute resolution, but the state government advances the Development Tribunal as a tribunal that provides a low-cost, speedy dispute resolution option on certain technical matters, and this is set up in the Planning Act 2016. So I'm a member of the Queensland Civil and Administrative Tribunal, and we have a similar mantra, a similar way of operating, that we are meant to be low-cost, speedy dispute resolution. So the Development Tribunal is similar in its overview in that regard. Now, coming back to the Planning and Environment Court, when it considers a development application which is subject to a dispute, it does so in a particular manner. It does so with a particular emphasis and from a particular starting point. Now, Scott, Kim, do you know what that starting point would be? What is the way in which the Planning and Environment Court considers a development appeal?
Would it be something to do, like if you're going to appeal a decision, it would need to be based on some error of law, perhaps, to actually... So I just remember reading there's a sort of a limitation there. It's either by fact and evidence, or it's by some sort of error in law, or an appeals to actually go through. I'm still sort of trying to get my head around all this a bit, but
no, that's good.
Yeah.
No, that you've.
Is this where you're talking about? Sorry, John. Is this where you're talking about judicial review rather than a de novo hearing?
Exactly. That's exactly. You've both identified what it is that I'm looking to draw from you. So, what do you think, Scott? Do you think it's a judicial review or a de novo hearing in the P&E court?
I thought it was a judicial review where they just look at the circumstances as to whether or not it was a lawful decision rather than the correct and proper decision.
Yeah, actually, I'll go the other way. You're right. There is a difference between, you're both right. There is a difference between a merits review, which is the de novo decision hearing, and a judicial review. And Kim, you're absolutely right that judicial review deals with issues to do with the lawfulness of the decision, whether the decision was made in appropriate manner, whether there was an absence of bias, for example, and whether the decision maker had appropriate jurisdiction to hear the matter. But generally speaking, when you read cases in the Planning and Environment Court, they will be cases that are heard de novo in what we call a merits appeal situation. And we contrast the merits appeal with the judicial review. So judicial review is where a court looks at a decision made by a decision maker and effectively says, has the decision maker made a decision in accordance with its lawful power to do so, and in the absence of bias or anything else which would vitiate that decision. Where a merits appeal is concerned, it's different. A merits appeal is where the court, as it were, sits in the shoes of the assessment manager. That's kind of the saying that we use. And the court then determines the matter based on what is the correct and preferable decision in relation to the matter. And it does that by hearing the application afresh. It will hear the application based on the evidence that it has before it at the time, rather than necessarily the evidence that was available to the assessment manager when it made its decision. So the court is charged with the responsibility of determining the application on its merits and is not so much concerned as to whether the assessment manager acted lawfully or not. Basically, the P&E court will start afresh. So it's not for the court to focus on the decision-making process of the assessment manager, which would be the case in judicial review. Essentially, one way to look at a merits review is to say this, that the court becomes the assessment manager through the merits appeal process. Again, looking at QCAT, we have a similar regime in relation to things like blue card applications. So, for example, someone may apply for their blue card. That may be assessed by Blue Card Services. If the person is refused a blue card, they have the right to appeal to QCAT, and a member such as I would hear the matter afresh as a merits review. So we're hearing the matter based on all the information in coming up with a correct and preferable decision. So you'll see this concept of merits review appeals referred to in a number of different areas of law, and you contrast that with judicial review. So I hope that makes sense, but thank you for your contributions there. Now, early on, Kim was correct when she said that assessment managers are usually at the council, but sometimes they're not. The assessment manager is not always someone from a council. Most applications are assessed by the local government. However, the state government may assess in circumstances where there is a state interest, and it will become the assessment manager through the State Assessment and Referral Agency when there is a matter of state interest involved, and we call that acronym SARA, S-A-R-A, State Assessment and Referral Agency, SARA. So if the state specifies that it has a particular interest through planning regulation, it assesses those provisions through SARA. Yes, like a new inland rail project or something substantial. And we'll talk more about environmental impact assessment and statements next week. But generally, the assessment manager will be the council, sometimes it might be the state. And when the state is involved, it will consider its decision, and indeed every assessment manager must consider the decision based on the state planning instruments. Now here's the second major change that we see through the introduction of the Planning Act 2016. That is the hierarchy for planning instruments. So when you're reading cases, when you're considering an application, when you're considering environmental law, you must consider the decision that is made in the context of planning instruments. I know it sounds boring, but it's very important. So, what are these planning instruments? Well, basically, there are two types. There are state planning instruments and there are local planning instruments. No surprise that the state planning instruments are regarded as higher in the hierarchy than local planning instruments. How many state planning instruments are there? Do you know? Do you have a guess? Under the current regime? No? We'll go with two. So what you need to do is look at state planning policy and regional plans. They're the two state planning instruments, state planning policy and regional plans. Local government, well, there are three local planning instruments, and they are planning schemes, temporary local planning instruments, or planning scheme policies. For some guidance on these, there's some excellent material on the websites. So have a look at information in some material called Guidance for Applying for Regulated Requirements to Local Planning Schemes, or Community Engagement Toolkit for Planning, or State Interest Guidance Material. See if you can find that material. The reason I'm stressing that is this. If you have a question in the exam, for example, which requires you to give some overview of the planning process, or a question that requires you to give advice to a community organisation seeking to deal with a planning issue, then having a look at some of these toolkits online would be a great assistance. And it sets it out really nicely. So, for example, the Community Engagement Toolkit for Planning is a really valuable resource in that regard and sets it out pretty simply. So I mentioned that with the introduction of the Planning Act, we had information which was previously in the Sustainable Planning Act now spread into three different areas. The Planning Act itself, the Planning and Environment Court Act, and the third is the Planning Regulation, which is 2017. So the Planning Regulation states which entity is responsible for assessing and deciding an application. So it deals with a lot of the mechanics associated with these issues. That entity, as we know, is the assessment manager, and in most cases, as Kim said, it is the council. But some require the referral to the State Assessment and Referral Agency, SARA, as we discussed before. So have a look at the planning regulation to give some overview of how the development processes work in practice. So in terms of the development process, I'll make these comments. I mentioned that not every development is an accessible development. In fact, the default position under the Planning Act is that all development is accepted development, accepted as in we will accept it, unless it has been identified as accessible development or prohibited development. It's a lot simpler than it used to be, actually. But when the development is accessible, that's when an application and an assessment is required. That makes sense, doesn't it? So the Planning Act is saying all development is permitted, it's all accepted development, unless it's accessible or it's prohibited. If it's prohibited, forget it. If it's accessible, it means we're not going to allow it to be accepted development until we, the executive, have had a good look at this. And it's the Planning Act that provides for which developments are accepted, which are accessible, which are prohibited. Have a look at the development assessment rules which set out the process of how a development application is assessed and decided. And every development application is different. So I can't give you one set of required steps for assessment because that will vary based on a number of different criteria. Okay, so here's the thing that I really want you to take away from this and try and find. It's kind of fun. I like this. This is I mentioned before, the website for the Department of Infrastructure, Local Government and Planning. I didn't use those words, but that's the one I meant. So have a look at the Department of Infrastructure, Local Government and Planning website. It's very instructive in terms of providing hands-on information, particularly with respect to this planning process. So if you read the Planning Act and your head starts to spin and you can't really conceptualise where these development applications are considered and by whom and how, go to the website and it will lay it out for you in an interactive manner. So when you go to the website, find the planning link at the top of the website, go to the current system, which is the Planning Act system, then go to map your development application, and you'll find it will ask you a series of questions. Just answer the questions, yes, no, it doesn't matter. And what it will provide you at the end is a lovely flowchart that tells you exactly what are the steps, what are the time periods involved in terms of number of business days, etc. And it will tell you what are the options as you proceed. So if you do that, using a couple of random things, it'll all start to make much more practical sense. And if you have a question that relates to dealing with an impact assessable development application, which involves a referral, an information request and a public notification, for example, at the start, if you look at the Act, you might say, oh, there's no way I could possibly answer that. But if you know to answer the question, all you have to do is go to the links in the government website, follow the links and it'll provide the answer. You'll get a 100% mark and it's really simple. You do it in 5 minutes. Does that make sense? So that's my tip for this evening. And that really covers all the information I wanted to cover tonight. Are there any questions, Scott or Kim? All good? Kim?
All good.
All right. Thank you very much, Scott. Kim, any questions?
There probably was a couple in relation to week 5, but I'm still in the process of uploading that, so I think I'll upload that and wait for some sort of guidance with that. So I'll leave it to there. But other than that, yeah, all good. Thank you.
And you can ask through you, crew, as well. And thank you for contributing as you've been doing. All right. So next week is Boxing Day, as I recall. So that's a holiday week. The week after that is the New Year week, which is plenty of holidays. And what I'll do is I'll pre-record a session to supplement what's there already. So there will be no live session on the 2nd of January. So we'll recommence with a live session on the 9th of January. Okay. And as for now, we might wrap up. Thank you very much for attending. All the best.
Thanks, John. Merry Christmas.
Okay. See you then.
Have a good time.
Okay. All the best. Bye.